So good morning, ladies and gentlemen. It's another of the Altamimi Construction and Infrastructure seminars with a specific focus on the Kingdom of Saudi Arabia. Speaking today are my colleagues, Dr. Abu Bakr Jabala, who is with me here in Riyadh, and also my colleague Ewan Lloyd in Abu Dhabi. It's pretty much the same sort of format as we've had previously, which is that we'll be speaking on the topics of insurance, indemnities and damages for about 45 minutes or so, and then picking up any questions at the end of the session. It's relatively informal in the way in which we're dealing with this, and insofar as we do get any questions that you put to us through the chat box, then we will endeavour to deal with them as we go along, although it's more likely that we may pick up on them at the end. So I'll hand over to Ewan, who is then dealing with the first section of today's talk, which is insurance. Ewan.
Thank you very much, Andrew, and good afternoon, everybody, and thank you for joining this this webinar. And as Andrew says, my section today is about typical insurance requirements in construction projects in Saudi Arabia. Next slide, please. And so on the first slide, I've kind of mapped out some kind of typical insurance type requirements you see typically in the Saudi Arabian market. And then in the subsequent slides, I've got some more nuanced points and issues to note. And so to kind of kick things off, I think before you kind of get into a discussion about insurance, we've got to kind of trace back and look at the actual allocation of risk under the contract. And it kind of follows that if you've accepted a particular risk, it's prudent, either from a commercial perspective or maybe the contract mandates that that risk is actually insured. And so if you look at the liability or liability for risk of the project during the construction phase, contracts invariably specify that risk vests in the contractor until these works are actually taken over. So it therefore follows that the contractor is required to take out contractors' all risk insurance or insurance for the works. So that if the works are damaged or harmed during the construction phase, then that insurance will apply and respond. Other typical insurance policies in the Saudi Arabian market are third-party liability insurance. And as the name suggests, this basically covers the parties in respect of any third-party claims which may be brought in respect of the project. So typical examples would be if the works damage any third-party properties, that may be neighbouring property to the actual site, or maybe when plants and equipment are being delivered to the site, they may cause damage to the actual roads and infrastructure outside the site. But it won't actually apply to the actual works themselves, because the works themselves are covered by the contractor's all risk insurance policy. And also, if any third parties are injured by the performance of the works, then third-party liability insurance will respond. But then, of course, third-party liability insurance won't actually cover the contractor's own workers on the site, because these workers are covered by workers' compensation insurance, which is a mandatory requirement under Saudi law. Another key insurance requirement or policy is that of professional indemnity insurance. And very briefly, professional indemnity insurance, I'll discuss this in a bit more detail, applies to design obligations. So if there's an architect or a structural designer on the project, they'll be required to have professional indemnity insurance. And also anybody else undertaking or providing any professional services. So, a project manager or a quantity surveyor will typically be required to have professional indemnity insurance. I've referred to delay in startup insurance just because, in my experience, this insurance is becoming more prevalent in the market in Saudi, particularly in the manufacturing and in the manufacturing sector. And basically, this is kind of coming off the back of employers' concerns that if a project is delayed, the LDs may be entitled to claim under the underlying construction contract, may not actually satisfy or fully compensate them for the loss that they've suffered. But delay in startup insurance is a fairly bespoke product. A lot depends on individual circumstances associated with the project in question, and it can be quite expensive to acquire. But like I say, it is becoming a bit more prevalent in the market, from my experience at least. And then the final insurance I just want to mention is that of inherent defects insurance. And this is fundamentally insurance in respect of what was more commonly known as decennial liability issues. And my colleague Abu Bakr in Riyadh has got some pretty in-depth knowledge on this insurance, and so that's covered by the next slide. And at this point, I'll just kind of pass the floor to Abu Bakr just to explain a bit more about inherent defects insurance.
Yeah, thank you, Ewan. Thank you, Andrew, for that. And good afternoon, everybody. As Ewan has mentioned, just inheritance and defect insurance has recently introduced here in KSA. The application of such scheme has applied only on the private sector now for the non-governmental project, and they started in Riyadh municipality, and they now at May 2nd of May 2020, and now started the application in the whole country. So Saudi Arabia has recently introduced the law and regulation that have applied decennial non-fault liability regime and mandatory inherent defect insurance. This system has been introduced by the new Saudi building code, which has been amended in 2019 and 2019. And this, so we are going to talk into two parts. The first is the decennial non-fault liability and the mandatory insurance. The first, I would like to talk about the decennial non-fault liability, which is applied on the both sector, governmental and non-governmental sectors, and the law applies to supervising designer and the contractor and design inspector defect in their design. The Saudi decennial liability regime applies to all type of construction, actually, construction work in both the private and public sector, and also in the constructed building, the destruction or modification of the existing building. This decennial liability, allowed the Saudi government to introduce the Saudi mandatory defect insurance scheme, which is introduced by the Minister of Municipality, in 2019, and then start applying in the 2nd of May. The inherent defect insurance is regulated by the central bank, KSA, which provide a sample of the schemes. The period of insurance is 10 years, which commences from the certificate of practical completion, or the issuance of certificate of approval, or the issuing the endorsement. This regime actually allowed the owner of the building to get get judgment from the court regarding the liability, to get the money from the insurer, and to fix the default on the building, and then before the contractor leave the country or there's no assets. So this system is new in KSA, very welcome. At this stage now, the insurance is only apply on non-governmental project, but we may in the future see that this extended to the governmental project.
Thank you, thank you. I'll pass my again to Andrew
To you, and I think you've got a couple more slides to finish with you.
Yeah, back to me. And can I just ask as well, Abu Bakr, in terms of saying liability insurance, am I right in thinking that a contractor is required to acquire this insurance as a precondition to obtaining a building permit?
Yeah, exactly. This is the case now that the contractor now before they start the building, they're required to meet some requirement, and before they start the building. And another work maybe will be in line with this new scheme, that the contractor need like inspection for the work before they start, which I mean the insurance company need to inspect the process of buildings to recognize that thing is going very smoothly, because they need to follow up with the contractor the process of buildings.
Yeah. Oh, thank you very much. That's very very informative. Thank you. Next slide, please. So in this slide, I'm just going to discuss about a few fairly typical issues and key points to note about insurance policies and how they operate in a construction context in Saudi. And I put down various kind of bullet points to address these. So the first one I put down is the amount of cover. And look, I mean, the amount of cover will very much depend on a case-by-case basis. But I suppose there are a few common rules of thumb, if you like. And I suppose in terms of contractors or risk insurance or insurance for the works, it's typical for the contractor to insure the works for the full reinstatement value, plus a margin of maybe 10 to 20% to cover contingencies and other professional costs and that kind of thing. In terms of professional indemnity insurance, that really depends, like I say, depends on the nature of the project. So in terms of some of the major projects which are taking place in Saudi Arabia right now, it wouldn't be uncommon for a major lead designer to be required to have PI insurance in the sum of maybe 300 million Saudi riyals or up to 500 million Saudi riyals. We're talking about a smaller project. I mean, it wouldn't be uncommon to have PI insurance of maybe as little as 10 million or 20 million. Next bullet point is the extent of cover and exclusions. I've mentioned this because I think sometimes there's a tendency to believe that because there's an insurance policy in place, all the issues and all the risks have been properly addressed, and the risk has been transferred, if you like, to the insurer. But like with any other legal contract or document, the devil is very much in the detail. So it's very important to actually scrutinize the wording of the policies which are in place. I've just got a couple of examples just to highlight this issue. And I'm mentioning these from a design perspective. And this is partly because I think the market in Saudi is imposing more and more robust requirements on designers. So, for example, fitness for purpose. We're seeing that more and more in design appointments in Saudi, and also fitness for purpose is referred to in FIDIC forms of contract. But what you do find is it can be quite difficult to actually get a fitness for purpose insured under the terms of a PI policy. Another thing I just want to flag up is this what's called a contractual liability exclusion. And I've seen this a couple of times. And what this clause basically says is that the insurance policy won't respond to the extent that the designer has accepted any liability that exceeds the liability at law. So, for example, the designer agrees to perform the works or to perform the services in accordance with, say, best international practices. That's unlikely to be covered as it would be caught by the contractual liability exclusion. And the other issue about this is it can be quite difficult to actually establish what the basic position at law is. So I recommend that anybody who's got PI policies looks at the wording quite closely. And then this a final point is that of penalties. And so as CSAs are kind of evolving in Saudi, particularly with the design CSAs, we're seeing more and more liquidated damages regimes in CSAs. And even if you have a very kind of robust and well drafted and inclusive PI policy, it's unlikely that any kind of penalties will actually be covered under the terms of the PI policy. So any penalties which are incurred are likely to come out of the pocket of the consultant. Next bullet point, I put down duration of cover. And so just going back to the example of contractors or risks insurance, there's a basic choice as to whether this policy is in place until the works are taken over or until the expiry of the defects liability period. And so the position under FIDIC contracts is that contractors or risk insurance remains in place until the expiry of the defects liability period. And that's fine. The only point I've got to make about that is you've got to be kind of quite careful when you look at the interface between different insurance policies in place, because once the works have been taken over, the employer will invariably take out his own insurance policy, because at that stage the project will have become a revenue generating asset. And so you've got to make sure that the interface between the different insurance policies is properly addressed. And an example or key risk which should be considered is that of if each insurance policy says that this policy won't respond if there's another policy in place which covers that loss. And so you could get a situation where both policies kind of point the finger at the other policy, meaning that there could be an impasse could be reached quite quickly. In terms of deductibles, that's the payment that the insured party is required to make out of its own pocket before the actual insurance proceeds can be released. And sometimes, particularly in bigger forms, in more significant construction contracts, employers sometimes specify limits on deductibles because they want to get access to the insurance proceeds as quickly as possible, without having to concern themselves with any kind of cash flow issues that which a contractor may have, which may delay the deductible or the excess being paid. In terms of insured parties, I put down this because typically in terms of contractors or risk insurance and also third-party liability insurance, these policies are typically under the names of both the employer and the contractor, which makes sense because claims could be brought against either the employer or the contractor. But the key thing to note about co-insured parties is that the underlying insurance policy should have a clause which basically deems the employer and the contractor to be separate entities. And so in effect that they are insured under separate policies, although in reality they're insured under the same policy. And this is because if in the absence of such wording, the employer and the contractor may well fall under the definition of the insured party. And it follows that the insured party can't seek to sue itself. So, for example, the employer wants to claim against the contractor subsequently, and both the employer and the contractor are defined as insured party. That could prevent any claim from being brought under the insurance policy. In terms of the identity of the insurer, just a couple of points to make there. First of all, it's important that the insurer has got a good reputation, a robust balance sheet in place as well, so that any claims which are made are likely to be paid out in a timely fashion. And then another just add-on point I just want to make as well in the context of professional indemnity insurance. Sometimes contracts specify that the professional indemnity insurance is required to be placed with a locally admitted Saudi insurer. And so in this situation, it can be prudent. In this situation, it should be possible to acquire a fronting policy from a local Saudi insurer, which basically is back to back with the underlying insurance policy. In terms of evidence requirements and consequences of not insuring, well, insurance is a fundamental requirement of any construction contract, and so it's unlikely that the contractor will be granted access to site if he hasn't got the required insurances in place. Insurance requirements are checked, or they should be checked on a fairly regular basis by the contract administrator. If the insurance policies have lapsed, typically there'll be a clause under the contract which enables the employer to acquire the lapsed insurance himself and to recover the cost of so doing from the contractor. And there may also be some more draconian remedies under the contract, such as withholding payment until the insurance has been acquired, or even termination. Next slide, please. In terms of notification requirements, doesn't kind of flag up this point, particularly from a PI perspective, and it's typical for PI, professional indemnity insurance policy, to state that if the insured party, so for example the design consultant, is a claim has been brought against the design consultant, or the design consultant considers that a claim is likely to be brought against him, he's then got to notify the insurer of that event as quickly as possible, as soon as practicable. And if he fails to do so, some policies specify that a time bar actually applies, and the insurer may then rely on this to deny cover. So it's very important that all notifications are given in a timely fashion. And of course, this requirement interfaces with the question of contractual time bars and how enforceable are contractual time bars under Saudi law. And we always take the view, as I think we've said in previous sessions, to always err on the side of caution. It's very prudent to always adhere to these requirements, particularly because the freedom of contract, principle of freedom of contract, does prevail in Saudi, and time bars are becoming more and more prevalent across the legal landscape. In terms of project-specific cover, this is more a point from a PI perspective, and just to take a step back, it's typical for designers, for example, to procure on an annual basis a PI policy which will cover all their projects for that year. That policy gets reviewed on an annual basis, and if you are a fairly kind of sizable design consultancy, you may be undertaking hundreds of projects a year in different jurisdictions across the world. And so for that reason, some employers sometimes worry that maybe the designer's PI cover may be exhausted by a claim brought against that designer under a totally separate project. And so for that reason, it's not uncommon, particularly on the bigger projects, for the employer to require that project-specific PI cover is provided for that project in question, and that's fine. But I've just got a couple of kind of comments and traps just to be aware of. I suppose the first issue is that the extent of cover available on a case-by-case basis in respect of specific cover may not be as robust as the cover that's available under a group policy, because there's less bargaining power. And then the other kind of point is, which is very kind of basic point, is if you are a designer bidding for a job, it's really important to scrutinize the insurance requirements and to identify project-specific cover requirements, because it can be quite an expensive insurance policy to acquire. And if you're aware of this cost during the tender phase, you can pass that cost through to the employer typically. But I'm aware of situations where consultants and designers have missed the fact that project-specific cover is required, they've actually had to acquire that PI cover themselves after the contract has started out their own pockets. That's just a red flag to note. Just the penultimate point, just about the interface between insurance and caps and liability. Sometimes, I come across the proposition that a party's liability is de facto capped at the extent of its insurance cover. That's not the case. So just going back to an example of professional indemnity insurance. So, for example, a consultant has a PI insurance of 10 million Saudi riyals, and a design defect occurs, and it causes loss of 20 million. That additional 20 million can be recovered directly from the pocket of the design consultant. And so it's very important that the concepts of PI cover or insurance cover in general and that of liability are delinked, and any caps and liability need to be expressly stated under the contract. The final point is just about subrogation. And subrogation is the right that an insurer has to step into the shoes of the insured party, and then to bring a claim to recover against the party who actually caused a loss, which was kind of paid out by the insurer. And just a point to note that sometimes in construction contracts and also design appointments, sometimes see a clause which says that the contractor or the designer agrees to waive all subrogation rights which may otherwise exist. And so that's a pretty kind of broad clause. Before waiving any rights of subrogation, I think it's very important to actually link it back and check that you're actually permitted to actually agree to such subrogation rights waivers under the underlying insurance policy. So that's a very kind of quick run through of the issues I wanted to discuss on insurance. So I'll pass the floor through to Andrew now, who will discuss indemnities and damages.
Thanks, Ewan. And of course, one of the reasons why we decided that we would group these three topics together is because so often there is an interrelationship between the insurance clause, the indemnity clause, and the damages clause. And one thing I do want to emphasize as I move from part one to part two is that just because somebody has a liability to carry out take out the insurance doesn't mean that they also have that liability. And one of the warnings here is there is a trend towards project insurance in KSA. And insofar as that project insurance is being taken out by the employer, that does not mean that the risks in the project are with the employer. And it pays for really careful consideration of what are your risks, what are the insurance obligations, and insofar as you have a risk, have you made sure that either your own insurance is appropriate or that the insurance by the employer or the other party is sufficient for the risk that you're taking? I just want to emphasize that point. Okay, so on to the next slide. And the reason why we're dealing with, or I'm dealing with indemnities, is just to really illustrate to the audience that in so many standard form contracts in English, the word indemnity or indemnities is used. Now, the way that translates into numerous other languages is not how it is meant in a very specific legal sense and how it would be interpreted under English law. Because an indemnity obligation is a very different obligation from a liability for breach of contract. And I'll come on to how that can be really important. And that's why I've said here that it is important to remember that what you're exposed to and the way the contract might operate in respect of an an obligation expressed as indemnity might work in a very different way from a typical breach of contract claim. And one aspect, and it's the final bullet point on that slide, is that in English law, at any rate, the concept of an indemnity and a breach of it will mean that the extent of the damages that can be recovered are potentially significant. Now, the normal remedy of damages in English law is broad enough, but if you have an indemnity obligation and the word indemnity is used, then usually that will mean that there is a very much greater scope for recovery, such that there's no real concept of foreseeability or remoteness. So you've incurred it. And secondly, the party does not have this obligation to mitigate what its damages are. So we often hear about an obligation to insofar as something happens, that a party's obligation is to limit the exposure that the other side might have. But when it's expressed as an indemnity in English law, there isn't that limitation. So damages under an indemnity can very quickly run away with you. I mean, it depends on the circumstances, of course. Sometimes the damages under an indemnity obligation, when they're calculated, may be very similar to those in breach of contract. But there is this potential exposure. So next slide, please. And then what I then am doing in this next slide is to highlight what are the typical obligations which are referred to in standard form contracts as indemnity obligations. And they are usually limited to those in relation to death or personal injury. You can see that it's typical in virtually every jurisdiction that you can't limit your liability, and that it will be on an indemnity basis. Quite often, and this is then a link with the insurance policy, it may well be that where insurance is available, then the liability is expressed as an indemnity. And I give those examples there, and Ewan's already touched on them, of death or personal injury, professional indemnity, third-party property. Very often, any obligations in relation to the infringement of third-party intellectual property are expressed as indemnity obligations. And you'll also get a host of others. I mean, a lot of them are sometimes project-specific, but you will also see indemnity obligations in respect of, for example, breach of statutory duty or fraud or certain sorts of deliberate misconduct. And my link then is to the FIDIC forms of contract, and we'll be touching on specific clauses from the FIDIC contracts a little bit later on. The FIDIC contracts take a very typical English approach to what is going to be covered by an indemnity obligation. And I reiterate the point there, that once you've understood that you have an indemnity obligation as distinct from a simple liability in damages, then you need to be looking at your contracts and being comfortable that that indemnity obligation is one that you accept, and if not, that there are appropriate limitation clauses in place. Obviously, certain obligations, like death and personal injury as an example, are imposed by law, and they're pretty much non-negotiable. And then I link it back into the whole question of insurance. Then it should be that if your insurance policy is broad enough, where you accept an indemnity obligation, then your exposure, other than for the policy not responding or a certain level of excess or deductible, it should mean that you're pretty much covered. So next slide, please. And then, I mean, my link then into Abu Bakr is just going to speak here, is that generally speaking, and this is partly, I think, to do with the translation of the word indemnity, within the Gulf, there isn't, within either the GCC codes or within Saudi, that distinct difference that I'm describing between an indemnity obligation and a damages obligation. But nevertheless, there's potentially still the exposure. So I'll just hand over to Emma back.
Exactly, as actually Andrew has said, the concept of indemnity has the Gulf country and the GCC is not well developed. So, especially in KSA, I mean, the damage, the principle is the damage shall be removed. So it is either under the concept of the breach of the contract and the indemnity phrase or any other clause. So the general concept is the damage on the party shall be removed by the other party. So the principle applied now in practice before the KSA court that if one of the parties suffered damage and the other party was the cause of that damage should be removed. Regardless of the concept of that damage, which is like indemnities or other concept of the contract. So as soon as one of the party goes to the court and proves that he suffered a direct damage from the conduct of the other party, so the court will ask the other party in order to remove that damage based on the general principle in Sharia that damage should be removed. So this is the general concept of the KSA. So there is no specific differences between the concept of indemnities or the other kind of damage. So the general concept of damage that covers at this stage covers all the categories of damage, that all damage should be removed. So I'll go back to Andrew.
Okay. So if you go to the next slide, please. And this may be a clause. Sorry, then we move on to damages. So it's the link between indemnity and damages. So could we go to the next clause? Next page, please. So again, I'm looking at this particularly from a common law perspective, but then looking to link it to clauses which I'm sure many of you will have come across either in FIDIC contracts that we've entered into or other contracts which use similar sorts of terminology. So whichever legal system we're talking about, whether it's a common law, GCC or KSA, there will always be some general law relating to the recovery of damages, either pursuant to express clauses or implied clauses or the general law. And then there is always going to be some element of limitation, again, whether that's on a basis of foreseeability or consequential or indeed an express limitation. And then just to go into a little bit of detail on this slide in relation to the FIDIC suite, and I'm hoping the message is coming across that the language that is used in these FIDIC contracts is very much based on the language of the common law. So some of those remedies are specifically expressed as indemnity obligations. So the FIDIC contracts are generally quite balanced and are deliberately using the word indemnity in respect of those sorts of obligations that I've touched upon before, like death or personal injury, third party property, or a very narrow group of liabilities. What you need to look out for is where that same word indemnity is used in respect of a much broader category of liabilities. And it's very easy where that word indemnity is not properly understood for other much broader obligations to be included, either within the indemnity section or elsewhere in the contract. So wherever the word indemnity occurs, be alert to that. I mean, sometimes you'll see a clause that goes in which says that there is an indemnity obligation in respect of the performance of the contract.
Yeah.
And it may be that isn't as dangerous in a KSA context as it would be in, for example, a UK or other common law jurisdiction, but you definitely need to be alert to it. Obviously, then, if you're talking about a simple breach of contract, then the damages that will be applicable in respect of that are costs and losses It's something which I think is very important to try and remember. The distinction is often, again, lost in translation, not just between one language and another, but or between one legal system and another, but even with parties who are completely familiar with the language and the law. Cost, of course, is something which you're paying out. A loss is something which you never received because you weren't able to do something, or you weren't able to produce in some way because of the breach of contract, just to make that distinction. And then two clauses which are very, very key in respect of damages in the FIDIC suite. So, and they're repeated in other parts of FIDIC besides the Red Book, but the liquidated damages in respect of delay, there is an exclusive remedy. And we've touched upon in other webinars that we've put on about the enforceability of liquidated damages in the GCC generally. And of course, I think most people will know, they don't tend to operate in quite the same way as they might do in a common law context, because quite often the actual loss can be assessed, and rather than what is supposed to be the commercial bargain reached, which is that the figure is a balance, and sometimes they are very, very ineffective. And then limitations on recovery, which again in a common law context, as set out in clause 17.6 of the FIDIC Reg Book, are often an absolutely essential safety net for particularly a contractor, as we will find, may actually not really offer that same protection in a KSO context. So if we could just go to the next slide, please. So I just wanted to touch on this and then bring Abu Bakr in to look at it from a Saudi perspective. So I'm sure we're all familiar with this type of clause. It's something which is if it's not the FIDIC suite, then it's going to be included in some fashion or other in your contracts. Now, one aspect relates to this concept of indirect or consequential loss. So it's trying to limit both parties' liability in respect of that broader concept of losses. I then identify these two exceptions, one of which is if your contract is actually terminated, then these limitations won't apply. And then secondly, and I'm reiterating the point, that the limitation on the type of loss that you can recover is not applicable where you have an indemnity obligation. So can you see how if somebody starts tinkering around with the extent of the indemnities, all of a sudden this key safety net clause may open up to be much, much wider, so you've got absolutely no protection from it at all in terms of the limitation of type of damages. And then the second paragraph, the total liability, which is the financial cap element, again, it's a key part of usually a contractor's exposure, that it minimizes, keeps its overall liability to a particular sum, usually the contract price. But note again that in that list of exceptions, and this is just the standard FIDIC list of exceptions, there are those clauses relating to indemnities, and then we've also got the intellectual and industrial property rights. So again, if somebody starts playing around with the extent of the indemnities, either deliberately or not realizing the significance of the use of the word indemnities, the contractor's exposure is going to be not only in terms of the types of damage increased, but also the cap on liability may not bite. So there is this double potential for exposure in respect of indemnities in particular. And then I obviously at the end there, there is the typical exception to all of this, which is behaviour which is fraud or deliberate default or reckless misconduct. One interesting point, and it's come up with me not so much in KSA just recently, but it was in the UAE, was whether or not a deliberate failure to pay by an employer, where the employer refused to pay, knowing that it had issued certificates for payment, it just didn't pay. The contractor then terminated, and so on the basis of a FIDIC clause, was that then something which meant that the employer could not rely on any part of this clause at all? Now, I don't know, but certainly deliberately not paying on the face of it could very easily be argued as a deliberate default.
Yeah.
Okay, next slide, please.
Yeah.
So I just, this really then is just to set out for the purposes of compare contrast with what Abu Bakr is going to be talking about in relation to KSA is, you know, the civil codes in both the UAE and Qatar are fairly clear in terms of what it is that can be recovered. And I think one of there's 2 points to make. The first is that although the concept on one level of consequential loss is not recoverable under the civil codes because it's on one level too remote, actually in practice it's quite likely that those same sorts of damages will be recoverable. But the other point, just before we move to KSA, is that generally speaking, both in the UAE and in Qatar, contractually agreed limits or exclusions on liability will be enforced on the basis of the civil code. So next slide, please. So
the case in KSA is like a bit different from the other GCC countries, especially with the no availability of the severe code here in KSA. We are hopefully to see this code sooner than later. So I think the current case now, the principle on this contract is the Sharia principles now that applied on this contract. The Sharia principle now, the Saudi court respect the contract, the parties. So it's, the condition of the contract are respected by the court unless this contract is against any principle of Sharia. So as soon, so in this case, if the damage that can be recovered before the KSA court is the actual damage that has been approved by the party. So the actual direct damage is recoverable. The other damage is difficult. So the loss of profit is difficult to be recovered. But at this time, the Saudi court shall apply the Saudi law, which is based on Sharia. Sharia only recover the actual direct damage. The loss of profit is we have seen very rare cases where the Saudi court that the other party to pay the loss of profit, but this in limited circumstances, very limited circumstances. Regarding the limitation clause, the most contract here in the cap liability here for at 10% of the contract price. And however, if the party that proves to the court that the actual damage is exceed that amount, the court will typically adjust liability caps to the actual loss in the court, rather than enforce the contractual provision. This is in general with some specifications that with some specification where the court loss of profit that, as I mentioned earlier, the Saudi court adopt that to remedy this in very limited cases where there's a lot of condition has to verify. So this is the general principle in KSA perspective, and I will I'll let my Andrew just finish our.
Okay, just the last slide then, please. Just the last slide. Conclusions. Yes, there we go. So, yes, the statement of the obvious in a way. It's that there are shared themes and issues. It doesn't matter where you are, whoever the parties are, and whatever the law of the contract is. However, And this is based on our joint experience, might actually be getting near to 75 or more years of experience around the table between us, which is a sad thing slightly, but you know, it's, and I want to emphasize this, similar words may mean and have very different concepts in another location and jurisdiction. I think we've touched upon this. You know, what is damages? What are limitations on liability? What's an indemnity? Generally speaking, in a contract, try and avoid the use of indirect or consequential unless you actually define what that means. Be alert, and maybe this is my major message today, is the use of the word indemnities. Liquidated damages need to be treated very carefully, and then maybe this is the theme overall. The laws in one, if you've got one simple clause, which is your choice of law clause in terms of what law is going to govern the interpretation of your contract. And there is absolutely no question that if you insert into, or the other party inserts a particular law into that clause, then there is a really serious possibility that that very modest change can fundamentally change the risks in your contract. Okay.
Yeah, here just to add,
please.
just to have one point to Andrew's point regarding the law and the jurisdiction can change the risk. Here in case if the party agrees that the Saudi jurisdiction, the Saudi court will have jurisdictions and the applicable law is another foreign law, English law or whatsoever, and if the case here proceeded here in case the Saudi court will accept the jurisdiction and will exclude the foreign law and will apply the Saudi law. So this is very important. We have like a lot of clients come to us, so we have chosen the Saudi jurisdiction and a foreign law, but if the Saudi court accepts the jurisdiction, the Saudi court will apply the Saudi law, not the foreign law.
Yeah, important point.
Yeah.
Okay, next slide, which I think is then our contacts, and then we'll go through some questions. So we've got a few questions that have come through, and we're pretty much on time to try and deal with these in what we've got left. So one I've got, and this Ewan, is for you. If a PI policy is being used, does the designer need to disclose the fully insured amount to the employer?
Oh yeah, see, so this kind of goes back to the point I was making about global or group PI policy. So for example, you're a major design consultant, for example, and you've got a total limit of indemnity of say $200 million US. You wouldn't have to disclose that because you can ask your insurers for different PI verification certificates for different amounts. So you can have a certificate for say 1, 2, 5, 20 million. And it's a case of kind of tailoring the certificates you give to meet the PI requirements and under that particular contract. So there's no need to actually disclose the full amount of the PI insurance that may be at your disposal.
Another question that's come in, which I think is probably for Abu Bakr, is I think we touched on it on the slides, didn't we?
Yeah.
If the contract does not expressly require a locally issued insurance policy, are there any laws in KSA that would require this? Or are the KSA, SAMA requirements silent? Abu Bakr?
Yeah, yes, as I mentioned earlier, the contractor now is obliged by this decision by the Minister of Royal Affairs to have insurance for their project, for non-governmental actually project at this stage. Yes, there's the law now, which is the decision of the Ministry of Royal Affairs. Contractors are obliged to have ID and insurance before they start their project.
Yeah. Yes. Okay. And then one for me, I think it's and it links very much to that as an example, the FIDIC 17.6 clause. So if the contract has a cap on liability equal to the fee, which is the sort of thing that we've been talking about, but the PI insurance limit is higher, could there be an agreement under law that the cap on liability is increased up to the limit of the insurance for any claims covered by the insurance? Well, the point is that if the cap is enforceable, then that cap will apply to all claims, including those covered by insurance.
Yeah.
But if the clause is expressed in the same way as a clause 17.6 FIDIC clause, then you'll remember that claims under insurance are expressly excluded.
Exactly.
So it depends on what the contract says, but if there's no exception to the cap on liability, and the cap on liability is enforceable, then it will keep the limit the liability to that cap. So so now question: what are the standard exclusions from a cap in KSA? Can you cap your liability to gross negligence or reckless willful default? Well,
I think as we mentioned earlier, so the cap is like 10% of the contract, but when you prove to the court that the cap is like the liability is the damage is exceed that cap, the court will ask the other part to recover that damage.
And I think in relation to that second part, if there was any doubt if we were talking about something like gross negligence or reckless or willful default, the chances of, even if you haven't made it, even if it hasn't been made an express exclusion to the cap, it's going to be difficult.
It's difficult, yeah,
to rely upon a cap in those circumstances. Okay, sorry. Let me. If the dispute has arisen between the parties, they agreed to set up on 17.6. Yeah, I think this is the same point, isn't it? And this is definitely the concern that I think we've addressed today. Is in KSA, if you've got a clause which is a cap on types of damage and on the amount of the damage, there is a potential risk that a much greater risk in KSA, I think, than in other jurisdictions, that will not apply.
Exactly.
Okay. Anything else? Thank you very much. Yeah. So somebody's asked a similar question in relation to intentional harm, fraud, or the decennial warranty. I think generally speaking, most clauses which are limitations on liability will have an exclusion.
Yeah.
And the exclusion in relation to intentional, deliberate behavior. And the exclusion works in two ways. One is the types of damage that you can recover. And secondly, the cap on liability.
Yeah.
And I think what we're saying is in KSA, both might be challenged by the
great chance that the actual damage might exceed that.
Yes. Hold on, I'm just going to see if there's any. And then I think we're pretty much finished. Oh, there's an insurance one here. Can you explain how fronting? I actually don't know what that is, so I'm interested to hear your answer. Can you explain how fronting policies work?
Yeah, just very quickly, it kind of goes back to a PI perspective. And so, if, for example, a PI policy is I don't know, written in London or Hong Kong or wherever, but the contract says that the PI policy's got to be submitted or issued by a local Saudi insurer. It's typically possible to approach a Saudi insurer, and they provide physically a fronting policy, which is a back-to-back piece of paper, basically, which says it's issued by them. It's completely back-to-back with the underlying, overseas insurance policy, and that should satisfy any issues in respect of requiring fronting policies under the contract.
Yes. Yeah. Okay. Okay, so I think we're finished. Thank you all very much for your attendance. Thank you for the questions. As I've said many times before, we are running these as a series. We run those which are of general application across the GCC. We've got this specific KSA series, and we also do some in relation to Qatar. Thank you very much to you and to Abu Bakr, and we look forward to seeing you next time. Thank you.
Thank you.
Thank you, everybody.